So what has been held in this order is, my lords, that it is not in dispute that I am in possession of the property. It is not in dispute that this land belongs to me. This is the observation of this honorable court. My lords, if I would say that I am the original land owner of that property, my lords,
I don't know, sir, because
Please.
somewhere in paragraph 11, it has also been mentioned that lease deed was executed.
please. My lords, to my mind, subject to my lords correct me, I may be wrong, my lords.
No, I'm not saying you are wrong. Sir, I'm not saying you are wrong.
So my
Subject to certain questions which are already going on in my mind, that this is a relevant question.
Because this matter is per se the right to fair compensation and transparency in land, Acquisition, Rehabilitation and Resettlement Act 2013. If my lord would recollect, my lords, earlier it was Land Acquisition Act, which ceased to have existed. And now this new act has come into picture, my lords.
When this land was acquired?
Please, my lords.
When the land was acquired?
Lords, the land is not in dispute that it was in possession of the petitioner, and when since 1943 it was acquired by the petitioner, lords. With a letter dated 22nd of September 1940. May I read for me, lord?
No, I just want to know that why this petition is under Act 2013. Are you claiming compensation or you are against the compensation?
Lords, the relief which was sought at that point of time, my lords, when the metro construction was going on, when they have initiated the proceedings to take the possession of the land of the petitioner, then this petition was filed.
Right.
And because of the elongation, my lords, now that I'm before my lord and arguing the matter in detail, my lords, the work of the metro has been completed. And
but what is the status of that acquisition proceedings?
My lords, if my lord would recollect, my lords, the matter was once listed before this honorable court, with due respect, my lords. And what they have stated is, with a letter order dated 19th of February 2024, my lords. May I read for my lord? Please, my lords. By order dated 23rd of February 2023, passed by a coordinate bench of this court, the State Council was directed to produce
no acquisition proceedings are taken.
No acquisition proceedings.
Okay.
Now, my lords, even this honorable court in Indore Development Authority, my lords, and subsequent judgments that I would place before my lord, my lords, that even if I presume, my lords, if I'm in the possession of the property, my lords, my right to property as far as Constitution Act is concerned, though Constitution law is concerned, my lords, though I'm quite abreast of the fact that now it is no more a constitutional right, but yes, it is a right, my lords, which was supposed to be followed a due process of law as far as this Fair Compensation Act is concerned. And it is an admitted fact that no acquisition proceedings have been done.
So you mean to say that the land although the land belongs to you, but it has been taken over without any acquisition proceedings?
Without any acquisition proceedings.
Achha, first of all, sir, tell me about your titles.
Please, my lords. My lords, there's a chain of documents which I wish to demonstrate before this honorable court, and that starts from page 31, my lords.
Right.
Page 31.
This is an order by a Board of Revenue?
This is an order by Court of Revenue. And subsequently, my lords, in addition to, there are a chain of documents which establish that because this order demonstrate and conceded the fact that I am the landowner of the property, my lords. My lords, I'm reading para 2 for my lord. प्रकरण के तथ्य इस प्रकार हैं कि आवेदक भोपाल ग्लूज एंड केमिकल्स एवं प्राइवेट लिमिटेड कंपनी में जिनकी फैक्ट्री जहांगीराबाद और गोविंदपुरा में स्थित है, इसे भोपाल और ग्राम गोविंदपुरा में 6.88 एकड़ और भोपाल में 6.93 एकड़ जमीन दी गई थी.
So this order is for mutation, that is regarding mutation.
My lords, this consists and proves that I am the landowner of this property, my lords.
So whether the mutation entry is the document of title?
It is not, my lords. It is not. Now, my lords,
so at the most we can say.
I appreciate that, my lords, but may kindly see. I appreciate that. What has fallen from my lord is this.
Then why did you argue that then this proves that you are the owner?
My lords, what is the ownership as far as Fair Compensation Act is concerned?
Fine.
Please, if this order subsists as of now, and it has not been assailed by any honorable court, my lords, and may kindly see, it is their case. They assailed this order before this honorable court, my lords, and what has been held by this honorable court, my lord, that is also lethal for them, my lords. May kindly see the reply which they have filed, my lords, and that has not been assailed. That observation has not been assailed by them, my lords. That is binding, my lords.
So let us read this order.
I'm just trying to just cope up with my lord with the query that what had fallen from my lord. I would be in a position to have a clarity with that, my lords.
Right, sir.
Please, my lords. The reply of respondent number 1 and 4. The collector, my lords.
Right, sir.
And in addition to this, my lords, The document which they have filed is at serial number 6, that is copy of order passed in writ petition number 371 so and so, Bhopal Municipal Corporation versus Bhopal Cruise and others. That's only the relevant para. I would not trouble my note with that. It's a detailed order by this honorable court. Page 52, running page, para 11 that I am reading. Indeed, the land originally belonged to the estate of Bhopal and was allotted to respond number 1, which is me, Milots, the petitioner. The land was allotted in 2 parts. Initially, it was 6.88 acres and later 6.93 acres. And as such, total land at measuring 13.81 acres. The same land which is under dispute and pending adjudication before this honorable court.
Then a lease deed was thereafter executed.
Out of which 2.50 acre was later on acquired by the Municipal Corporation Bhopal for the purpose of establishing a slaughterhouse for which compensation was determined and then paid to respond number 1. So they took the requisition, the arbitrator was appointed, which I have annexed the documents, and then 2.50 acre was taken from me by the Municipal Corporation Buildings, which they are now claiming that this property belongs to me.
What is the nature of the allotment, sir? That will be the crucial question.
Because I'm reading that. And then I would come to the statute, the fair competition, what fair competition says about. Municipal Corporation Bhopal for the purpose of establishing a slaughterhouse for which compensation was determined and then paid to respond number 1. As such, respond number 1 had only 11.31 acre of land. The lease deed was thereafter executed by the Municipal Corporation in favor of respond number 1 as per the instructions in order passed by the state. An application was moved before the subdivisional officer under section so and so by respond number 1, but that application was rejected with a order dated so and so by the subdivisional officer on the ground that the dispute does not fall within the purview of section so and so because dispute is between the Municipal Corporation and respond number 1 and not between the state and respond number 1. However, that order was assailed by the respond number 1 before the Board of Revenue, and the Board of Revenue remitted the matter to the SDO, and then the December 2000 order was passed, which they have assailed before this honorable court. So what has been held in this order is, Milots, that it is not in dispute that I am in possession of the property. It is not in dispute that this land belongs to me. This is the observation of this honorable court.
Fine,
Which they have not assailed.
Am I not entitled to know the original nature of allotment?
Milots,
If you say that I am not entitled, then proceed further.
Milots, still, if I would
Which
say
is that document of allotment which was ultimately considered by the Board of Revenue.
Milots, if I would say that I am the original land owner of that property, Milots,
I don't know, sir, because
Please.
somewhere in paragraph 11, it has also been mentioned that lease deed was executed,
please,
right?
Milots.
So whether this lease would confer the title of ownership.
Milots, that will have to see if, subject to my lords, correct me, Milots, that will have to see through the December 2000 order, Milots, because that is subsisting.
I want to start from the very nature of the
Milots,
this allotment which was made in your favor.
that's exactly what I was taking through, my lord, to the documents, Milots. May kindly see the first document.
Please start with that document by which
Please.
the land was either allotted to you for the first time
Please, Milots.
or the lease deed as mentioned in paragraph 11
Please.
was executed. Have you filed the copy of lease deed?
Milots, all the documents that I have annexed, Milots. Annexure
Yeah,
P4,
yeah.
I'm starting from.
Annexure P4.
Milots, I'm reading that.
This is Al-Maulavi, Secretary to the Government of Bhopal in continuation of my letter dated 22/9/1943 to you certain consensus in connection with your proposed factory at Bhopal.
May I just give a short synopsis, Milots?
Uh,
Through the document, Milots. So I'll request my lord to kindly leave through the documents then, along with the dates. Milots, 22nd of September 1943, with a letter dated 22nd of September 1943, the government of Bhopal allotted a plot at measuring 5.81 acres to the petitioner. No dispute on that, Milots.
Then what was the nature of a title or rights which were transferred to you by this allotment order? Whether you were the licensee, lessee, ownership, gift, whatever it is. What is the nature of this allotment? Why the question of a lease arose at a later stage?
Milots, page, typed copy is at page number 48, Milots.
Yes.
Annexure P3.
Yes, sir.
Now, this is a chain of documents. Dated 22nd of September 1943. In reply to your father's application dated so and so, proposer to erect a glue factory at Bhopal and applying for grant of curtail concessions in connection therewith, I beg to inform you of the following order which have been passed by the government thereon. If the land required by you belongs to and is in the possession of the estate, it will be assigned to you free of cost. If the land required by you does not belong to you or be not in the possession of the state, the government will acquire such land under the Land Acquisition Act of the state at your cost and transfer the same to you. This is the first document, Vizor. Wherein
It
I
was free of cost.
yes, my lords.
Then whether the title can be transferred without any consideration and whether it was a registered document.
Lords, I ask myself here, because I pause there
Yes,
for
sir. Yes, sir.
I am being aggrieved by the act of the respondents. How?
Sir, in order to grant a compensation, I have to give a finding that you are the owner. You are relying on certain documents
Because I'm relying on that.
which are already in your favor. I'm not disputing any of your documents.
Please, my lords.
I just want to go through the nature of a title or right which was transferred
Lords,
to you.
then, my lords, I'll just take 2 minutes and I'll take my lord to the documents, my lords.
Yeah.
I would request my lord to kindly leave through these documents. These are imperative documents, my lords. The first document is at page 48. For the very first time, this land was allotted. My lords, may kindly come to page 50 now.
33,299 at the rupees per square situated. Map to this pattern having the following dimensions. P5 is the pattern, right?
Yes, my lords.
So a lease was given to you.
Yes, my lords. And that is at page 54, my lords, annexure P6.
Okay.
This lease made on the 2nd day of July 1956.
What was the term of this lease, sir?
Notes, it is mentioned there, the second lease is, true copy of the lease is page 61, my lords, 29th of September 1956.
What was the term of that lease? I'm
62.
concerned about the term of the period of this lease, sir.
It is not, my lords.
So without period,
It is not. Yes, my lords.
can there be any lease without any period?
My lords,
Oh, then another
What-
land revenue code. Yes.
what is,
Transfer of property then.
please,
J.
my lords, page 63, what is mentioned is only for 99 years, my lords.
Page 60,
63.
63. Where it
The
is
stipulation was not given at page 61.
fine, no difficulty.
Please.
Sir. Where it has been mentioned for 99 years?
My lords, page 63.
Where it has been
My
mentioned?
lords, at the above, it is written to, and which starts at act together also for the company to construct a road or roads. 1, 2, 3, 4, 5, 6, 7th line, my lords. Term of 99 years paying thereby. During the said term, the yearly rent of rupees 13
for
annas,
99
13 and plus 9 and so on.
So you are not the owner, you are a leaseholder. Now, one
Lords,
thing is clear.
this dispute subsisted, my lords. No dispute on that. I am not saying that there has not been a dispute.
Now,
And that's why I read for the very first time, my lords,
Fine,
the,
fine.
the
No
order of this honorable.
no difficulties.
Please.
Now, please come. Now, please tell me that on what date you were dispossessed or the possession of this land or the part of this land
Please.
was taken by this metro,
Please, my lords.
and whether you are running the factory
Yes, my lords.
still.
Please, my lords.
Is it so?
My lords, it's a part of land which was given. Whether that particular area of land where the dispute is pending adjudication before dishonorable court or not, whether that factory is on or not, that's not the question here, my lords.
There is.
My lords,
I,
no, my lords, to my mind, subject to my lords, correct me, I may be wrong, my lords.
no, I'm not saying you are wrong. Sir, I'm not saying you are wrong.
So my
Subject to certain questions which are already going on in my mind, this is a relevant question.
Please, my lords. I am completely one with one, my lords.
All right.
But my lords, I have a focus per se. This case, I am only focused about this fair compensation, my lords.
Fine.
And what
So
I
when-
found for my lord is what I found, my lords. I just read the statutory provision, my lords. Section 2.
Section 2. Section 2
Section 3 R, my lords.
R.
The statute as a running page says 11, my lords.
Yes.
I was conscious of this fact, my lords.
Landowner whose names as owner of the land, forest rights, is entitled to get to be granted better rights on the land under any law state including assigned lands. Any person who has been declared as such by an order of the court or
This is exactly what I found, my lords.
whose name is recorded as the owner, fine. Any person who is granted forest rights under the scheduled tribe, no.
No, I don't come under that, my lords.
Who is entitled to be granted patta rights, ये भी नहीं आ पाएगा.
My lords, 4. Any person who has been declared as such by an order of the court or authority.
Authority.
Now, the order which I have just stipulated before my lord, it is unassailable as of now, my lords. And there is no stay to that effect before from the civil court.
No, this order was passed by the Board of Revenue under the MPLR code. Right?
Yes, my lords. And in the objection is that in the land records, my name is not there.
Fine, fine. वो तो ठीक है सर. अब आप मुझे ये बताइए कि MPLR कोड इसमें लगता था क्या?
My lords,
Where the land has been issued, has been given on patta for establishing a factory.
my lords,
नहीं, let it.
this query, my lords, may I just submit
हाँ.
with due permission, my lords?
हम्म.
My lords, had it been a situation that this MP land revenue order,
हम्म.
which is being passed by the appellate authority, my lords, under revision, was not subsisted and effective, my lords.
Sir, if something is, now let me clarify my doubts.
Ji.
If something is without jurisdiction, I am not supposed to follow that.
My lords, if
So that's why I put a question to you, that when the land was allotted to you for establishing a factory,
please, my lords.
will it be covered by the provisions of MPLR code for declaring you as a Bhumi Swami?
My lords, but
Because if it is without jurisdiction, I can ignore that order. And if it is within jurisdiction, then I cannot raise any ifs and buts. I
No.
cannot touch the merits of that order because it has not been set aside and it is not under challenge.
please, my lords.
Right?
Please.
I can touch that order only if I come to a conclusion that it was without jurisdiction.
Please, my lord. So may my lord want me to read that order?
No. You have been assigned the rights of a Bhumi Swami.
Yes.
How that can be done in the MPLR code in respect of a land which was granted, which was leased out for establishing a factory? That is the only question. I have read the operative part of this order passed by the VOR. It says that the Bhumi Swami rights have accrued to you and your ये है इसका conclusion.
जी.
Right? अब ये भूमि स्वामी rights जो MPLR code में है सर, section के section में सर अपन देख लेते हैं.
Lords, before that, yes, I'll have to satisfy my lord on the query which my lord has raised, my lords. But 2 points that has emerged within my lords that I want to share with my lord, my lords.
Right, sir.
You know, the point is that if that was not the situation, my lords, I am not reiterating again, my lords. If that statutory provision was not there, I personally believe,
Sir,
my lord, they ought to have challenged that.
Sir, with the last statutory, non-statutory, humble request.
Please, my lord.
Why I am saying statutory? Because my order would be having a force of law.
Please, my lords. No, my lords,
Right.
I am saying
Right,
about
right,
December
sir.
2000 order.
Sir, just a minute, sir. What I am saying that if I hold that the order passed by BOR was without jurisdiction, is it not required from me to put this question to you so that you can answer that?
No,
I
sir.
can understand that this question has cropped up for the first time. You might not have seen from that angle, but
I have not, my lords.
no difficulty, no difficulty.
I have a respectful.
But as a judge, is it not expected from me to put a question which has cropped up for the first time in order to give an opportunity to meet it out?
Lords, may I just submit to that, my lords?
So,
I'm sure that I would clarify that, lords.
sir, my only request is that if you have not seen, then before proceeding further, please think it over. Would you like to make a research or not? Or otherwise come to section 158 or whatever it is, which deals with 185, I think, which deals with conferral of Bhumi Swami rights.
Lords, if my lord would help, my lord, presumably. Lords.
No, I'm not, sir. I'm in, sir, just a minute.
This
Sir.
is my query that has come in my passive mind, lords. I'm just sharing it.
What I always do is, before deciding any question,
Please.
I always share my doubts with the lawyers so that they can clarify this thing.
Please.
Right?
Please.
Because keeping a query in my mind and all of a sudden giving a judgment, I think that is not the
Please.
right.
Then I would do that. Lords.
So a Bhumi Swami right was conferred on you by the BOR.
Please.
And whether that can be done in respect of a land which was leased out for the purposes of establishing a factory. It was not for agricultural purposes.
Please, lords.
Whether a Bhumi Swami right can be conferred on the owner of the factory or the agriculturist under MPLR code.
Lords, I have just 2 reasons for that, lords.
Right,
This is not my contention, but I have only 2 reasons to
right, sir.
place before this honorable court, lords.
Uh-huh.
Lords, if presumably, my lords, if this query that has unleashed, my lords, and my lord would come up with the observation that whether this appellate jurisdiction which has passed the order.
I have not come to any conclusion.
Please, my lords. Because,
I am still clarifying my doubt.
because just one
And then I will come to a conclusion that whether my query, even if it is answered against you,
Please.
what will be the consequence of that in the light of the judgment passed by the coordinate bench,
Please, my lords.
right?
Please.
Sir, since you are aware of the entire facts, right from A to Z,
Ji.
so you may be able to understand the things very quickly, but I have not seen the facts.
Please,
I am at the stage of understanding the facts.
please, my lords. So, my lords,
That's why ultimately even I may say that my query was irrelevant because now I cannot do that.
please, my lords.
Ultimately, I may say so. I am at the stage of just realizing what the facts are.
Please.
Right?
Then I'll have to.
So, yes.
I'll see. I'll make sure that I'll
Yes, sir.
try to unleash that.
Now-
and go deep into that and try to find out as to whether this the jurisdiction point of view, which has
No,
from my lord, my lord, whether it has-
jurisdiction point of view will arise only if you fail to satisfy that the MPLR code is also applicable to the patta granted for establishing a factory. Had it been an agricultural land, I would not have raised that question,
Please,
right?
Please.
If MPLR code doesn't apply to such type of lease, then from where the Board of Revenue had assumed the jurisdiction, that will be the second question.
please.
And if ultimately I come to a conclusion that the order passed by the Board of Revenue was a nullity, then the third hurdle before me would be to how to overcome the order passed by the coordinate bench. So
Please.
these are the three hurdles. The third hurdle is for me. The first two hurdles are for you.
My lords, I would not bring much hurdles to my lord, my lords.
Huh?
But one hurdle which have,
Sir,
have already now come into picture and which has unleashed, my lords. So I'll have to answer that, my lords.
Yeah.
My lords, to the best of case, my lords, and to the worst of case for me, my lords, not to the query which my lord has raised, my lords. What would happen to the fate of that case wherein the Honorable Supreme Court has held as far as this Fair Compensation Act is concerned, where
Sir,
the trespasser has come into picture and they say,
Sir,
you have the power to take me.
I am, sir,
That's the only issue, my lords. So
sir, I am ready to cut short your arguments.
See.
Make a statement that you are a trespasser.
No, my lords, I would not.
No,
I'm just
sir,
presuming.
then,
I'm presuming. my lords.
no, sir.
Because my
Sir,
lord has
sir,
raised certain queries.
Sir, you can presume, but as a judge, I can't presume.
Please, my lords.
I have to give a finding. So there is a distinction. So try to understand that aspect or my difficulty. I cannot give a cannot pass a judgment that by presuming that petitioner is a trespasser, then this will follow.
My lords,
Can I write
that's
such type of
only my
judgment?
presumption, my lord. What do you-
No difficulty.
My
sir.
lord says I bowed on, my lords.
Can I write a two-line judgment that by presuming that he is a trespasser,
Ji.
this law would apply and therefore this order? Can I pass such an order?
No, my lords.
No.
My lord, may I just,
So
may I just share one judgment, my lords, of the Honorable Supreme Court
but let us,
with the query of my lord, my lords.
we will come to the judgment at a later stage. Let me come to conclusion
Please, my lord.
whether you are a trespasser or you had any right. After coming to that conclusion, then we will proceed further.
Please,
On one hand, sir, you have accepted, and even it is my view, we cannot pass a two-line order that in my considered opinion, he is a trespasser or he is the owner. I have to give reasons, sir.
that was my presumption, my lord. That's
No.
what Supreme Court has held, my lord.
What I'm saying,
And by this Honorable Court.
what I am saying, I am not talking about the law for the time being.
Ji.
I am trying to find out whether BOR had any jurisdiction to confer the Bhumi Swami rights on the factory owner on the strength of a lease which was granted for establishing a factory. Only thereafter, I will come to a conclusion whether you are holding the land as a Bhumi Swami or a lessee only. And then we will consider what are the rights of a lessee or a trespasser. अब मैं आपको लेसी लिखूं, ट्रेसपासर लिखूं, ओनर लिखूं, अब मुझे जो BOR का जो पहला ऑर्डर देख के मेरे दिमाग में जो क्वेश्चन आया, how it can be done in respect of a factory.
No, what?
So sir, you may be right that take the case to the worst that you are a trespasser, still you have a right.
Please.
No difficulty, sir. But I can't write the judgment in that manner. That is my difficulty.
Because this would have an impact to the civil court as well, my lords.
Yes.
The suit which
Apart from that, suppose if I pass a two-line order, after hearing the counsel for the parties, in my considered opinion, you are a trespasser, or owner, or leaseholder, whatever it is. It would be 1 out of 3. Therefore, you are entitled for this.
Please.
Can it be said to be a proper order?
No, my lords.
No. So it has to be preceded by the reasoning. that why I have come to a particular reasoning about the nature of your right in the property. And for that purposes, I require your assistance. And my habit is that before deciding the case, I always share my doubts with the lawyers so that you may answer during the course of arguments. And after the judgment is passed, then you may not have an impression, yeah, puch to lete, I had an answer to that query. Why should I compel you to file review or to file WA or SLP if the things can be corrected at this stage only? So is it a good practice or bad practice?
It is, my lord, it's very good practice.
Now, so my first doubt in my mind is whether BOR had any jurisdiction to confer the Bhumi Swami rights on a factory owner under the provisions of MPLR code. After clearing that doubt, then I will proceed further is that by virtue of lease, you are a lessee only and your lease is still subsisting because it is for 99 years and those 99 years have not expired. Because यहाँ पे दो self contradictory findings हैं. One says Bhumi Swami, another says lease. Am I not correct?
Lord, sir, through the documents, the chain of documents,
नहीं fine
the
fine.
provisional.
Sir मैं क्या लिखूँगा आपको leaseholder
Lord,
लिखूँ?
my lords, I am completely one with my lord, and whatever that has fallen from my lord, my lords, I truly considered that. I truly considered that, and I would make sure that I would come up with this. But the only issue, my lords, the sole issue which has now that unleashed, my lords, all of a sudden, but my lord had raised this query, my lords. My lords, what would happen if my lord would held now that this order does not have a vested powers and in the right?
I don't know, sir, nullity, and if an order is nullity, it can be challenged, it can be considered in the collateral proceedings also.
Because,
So
I was only focusing on the fair compensation.
that's why, sir, I said that I will not touch the merits of that order.
Please,
Because that order has not been assailed and I cannot reopen that order.
please.
Right? I can touch only if I come to a conclusion that it is without jurisdiction. And if it is found to be within jurisdiction, then whether it was rightly passed or wrongly passed cannot be touched by me. I am very much clear in my mind, sir. I cannot say that this finding is incorrect or that finding is incorrect because it has not been challenged. It is not the subject matter of the writ petition.
May I just ooze a confidence and say something?
Yeah, please, sir.
Because if my lord would help that as well, it would certainly have a lethal impact on
I don't know, sir.
On the petitioner.
Sir, I don't know because the difficulty is one order says Bhumi Swami, corporation says lease, and I am required to decide the question of question of compensation.
But
So either I would say that the civil court can also consider whether the BOR had any jurisdiction to pass such an order by thereby conferring the rights of Bhumi Swami. I can keep that question open. No difficulty, but that will not be affirmed by me or that will not be relied upon by me unless until I get satisfied that the Board of Revenue had a jurisdiction.
But may I just
Because as I know, MPLRC deals with the agricultural lands, and the conferral of Bhumi Swami right is in respect of agricultural lands.
There are very many instances which I have dealt with, Milots, with a very limited knowledge. Because when you file a petition and seek a relief before the Honorable High Court, Milots, the first thing that you are supposed to focus on predominantly that you will have to concentrate, Milots, and that is the under which law that you are actually filing this petition, Milots. So I was only focusing on the fair compensation.
No, sir.
I did not have this query which my lord.
That's why I said, because this question has cropped up for the first time.
Please.
You might not have prepared the case from that angle. And if you ask for some time, I don't have any objection.
I would, but I have an answer to that as well. But I would not contend today, Milots.
Yes, that's what I'm saying.
And then I would come back.
Had it been a case that it was already the subject matter, and if you say, sir, I had not seen, then I would have refused adjournment.
Please.
But this question has popped up for the first time. That whether BOR had jurisdiction in respect of a land which was given to you for establishing a factory. So, yes, it is my moral duty also, apart from my duty.
Then we'll have to see the writ petition filed by them, Milots, and I'll file that writ petition as well, whether they have challenged.
Sir, it is for you to deal with my question.
I'll do that.
But as you know, that even an order which is without jurisdiction, that is a nullity, and it can be challenged in the collateral proceedings also. I can deal with that aspect in this petition also, whether it was challenged or it was not challenged.
And
therefore, I am making it very much clear. Don't concentrate that I will touch the merits of the case. Don't think from that point of view, because I am not going to touch the merits. It is not the subject matter of this petition. And in this petition, I cannot say that order was not correctly passed or incorrectly passed.
Yes.
I can touch only to the extent whether the BOR had any jurisdiction or not.
Because for that, then I'll have to endeavor hard, my lords, to convince my lord that please, then I would always endeavor, try to take my lord not to that BOR, my lords, to under the statutory provision of right to fair compensation act.
Fine, this is no difficult.
Under right to fair compensation, whether
Sir,
these
you
can be-
started with BOR, therefore I looked at BOR.
because
Otherwise, I would not have looked into that order.
because I've read, my lord, section 3, which says that if, say, the order is under operation, then that also subsisted, and I've got the right to come before my lord and seek a compensation.
That's why. And whether if suppose if I say that it is without jurisdiction and it is a nullity, then again there will be some hurdle before you.
Then, my lords, one more thing that I would request my
Yeah,
lord to
please.
kindly consider, my lords. When there is no acquisition proceedings that has happened, my lords, and I've come before my lord for right to fair compensation, my lords.
No
My
problem,
lords, please
sir.
consider that as well.
No problem, sir. What I am saying at present, I have not reached to that stage, whether you are entitled or you are not entitled. First of all, your right or title is to be established, and then only I can come to the conclusion that whether you are entitled for compensation or not. First of all, let us clear the first hurdle. This is what my anxiety is. Because there are two documents which are self-contradictory to each other. If you had acquired the rights of a Bhumi Swami, then where was the question of lease?
And what
Is
would
it
happen,
not a
my lords,
is it not a self-contradictory proposition?
my lords, may I just submit, my lords, what would happen if these documents were being considered and corroborated with the revisional court, and revisional court has considered that and then passed the order, my
मैं
lords?
आपसे
That's my
कहूंगा,
issue.
मैं आपसे कहूंगा ना sir. Then those will be the hurdles for me, and with your assistance, we will try to clear up those
I'll
hurdles
do that,
also.
lords. I'll do that.
है ना?
Even my
But-
civil suit is also pending before the.
Fine, madam. अगर इनको compensation का अधिकार है, how can you take his property? क्या constitutional right नहीं है property का? ये शायद इन्होंने बोल तो दिया था, it is not a constitutional right. It is a constitutional right under 300A, and there is a judgment by Supreme Court also.
My lords, why did I not say? Because the terminology which was not coming at that point of time, my lords, the court has now taken the right from the constitution, and then it has become some vested right of that. So it was not coming in my mind. That's why I have not stated that.
No problem. Earlier it was a fundamental right.
Exactly, my lords, that's the point. It
Then
was not coming in my-
it was taken out from the chapter 3, and then 300A has said. 300A here. Now recently means about 2 or 3 years back, it has been held that it may not be a fundamental right any long, but still it is a constitutional right, and you cannot deprive a person from the property without following due procedure. So it is a constitutional right. Agar he is entitled to retain that property in whatever whatever capacity, can you take his property? That is the question. तो वो पहले हम इनका right determine कर लें, and then we will come to that question.
Because under Indore Development Authority, one of the judgments passed by the Honorable Supreme Court, they have dealt with the legal standing as well of a person.
No problem, sir. What I am
So I'll bring
intending,
that, my lords.
what
I'll
I am,
bring
no, what I am intending to say is, before ascertaining your capacity to hold that property,
Ji.
right? I would like to consider that in what capacity we were holding that property. If I come to a conclusion, okay, you are a lessee, fine. What are the rights of a lessee? Whether he is entitled for compensation or not, then another question would arise. If I hold that you are a Bhumi Swami, then no question would arise, right? क्योंकि वहां पे तो compensation होना ही पड़ेगा, without acquisition हो ही नहीं सकता है. फिर आ जाएगा कि whether you are a trespasser, फिर then we will consider from that angle.
Because then I'll have to prepare in such a way that I would not, then I would.
No problem, sir.
Not
I
to
have raised
with
this.
the
No.
revisional order, my lords. Why? Because it would certainly somewhere down the line would haunt and deliberate the order of the civil court as well, which they have filed now.
That's what I'm saying. Because this
Because
question has,
one of the order which was passed by this honorable court, my lords. Honorable-
sir, that aspect has the authority of or competence of BOR was not taken into
No,
consideration.
that's the issue, whether they have taken that issue there or not. my lords.
We will look into
We'll
that
have to find out.
aspect.
Please, so I'll do that. Because I don't intend to deliberate and then interrupt my lord while passing the order. My lord. But only one issue is, if my lord would dictate the order in such a way that I have to see this BOR as well, they would certainly take advantage of this before the civil court, my lord. So
I don't
would
know,
only
sir.
request, my lord.
Sir,
I would leave it up to my lord.
Sir, Sometimes some things are written in order to refresh our memories. And once I raise a question for myself, then I always decide the same. I will not leave it. Even suppose if I decide to leave it, then still I will keep it open, leave it open for the trial court. Because if an order is a nullity, then it can be challenged at any stage, even in a collateral proceedings. And the regular challenge to that order is not required.
Please.
है ना? And the trial court is also a court of law, sir.
But the issue is that every now and then, and I would be committing a same thing that I'm trying to find an analogy, my lords.
सर आप चिंता नहीं कीजिए, अगर हमने
the question is-
क्वेश्चन फ्रेम कर दिया तो एटलीस्ट आई विल आंसर दैट
My
क्वेश्चन.
lords, फिर एक क्वेश्चन जो मुझे लगता है, my lords, मैं उसके capacity में नहीं
बता दीजिए.
कि ये ऑनरेबल कोर्ट राइट टू फेयर कॉम्पनसेशन में अगर डिसाइड कर सकती है तो my lords एक वो भी क्वेश्चन.
Fine.
Please.
4500/2022. During the course of arguments, the counsel for the petitioner has relied upon the order dated 8th of December 2000 passed by Board of Revenue in revision number 501/PBR/2000, by which the Bhumi Swami rights were conferred on the petitioner. Accordingly, the following two questions emerges for adjudication apart from the other questions. Number one, whether the Board of Revenue, in exercise of powers under MPLR code, can confer the Bhumi Swami right to a person to whom land was allotted for establishing an industry or not. Number two, whether the aforesaid question or not, and whether, similarly, and if not, then whether it would be without jurisdiction or not. Number two, whether the competence of BOR, Board of Revenue, can be considered by this court in the proceedings arising out of non-grant of compensation under the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. And if you want to add something more in the order,
No, I can. So it was just
no difficulty, sir. Because what I personally feel is that if an order is without jurisdiction, then it can be challenged in the collateral proceedings also. And this proceeding would certainly amount to a collateral proceedings. So that was the another question which was already implied in the first question. But anyhow, since you wanted a specific question, so I have framed that out.
I just contended, no, I never intended to.
I am in habit of giving equal opportunity to myself as well as to the lawyers. So I am not shy of anything. I never sit with pre-decided mind. नहीं मुझे तो ऐसे ही करता है. Right?